It seems like every other day I'm seeing a headline of two major companies starting the process of merging together to form some newer, more mega company. Will this process continue until we have only one company called Coca-Cola, Nike, Halliburton, PepsiCo, Stanley, Steamer, ExxonMobil, Wendy's, Apple, Nike? No, that's stupid. But the importance of understanding the merger process is real, and they are a major part of economic activity. They highlight some possibilities and limitations of the data and the way that we think about what people are doing. Just look at the recent offer by Dick's Sporting Goods to buy the shoe company Foot Locker for $2.4 billion. How do you figure out whether this merger is a good idea or a bad idea? What's the data that can even begin to get at this issue? And how do the regulatory bodies decide to let it happen in the first place? Hello, I'm your everyman host, Brent Buckwright here, and welcome to Of Significance, the podcast that merges Dr. Nathan Woods and Dr. Steve Bronars into a room to talk about the right ways to think about data. Nathan, Steve, how are you?
Boy, when we merge, it's anti-competitive.
Doing great, Brent.
So today we are joined by someone whose merger experience spans pre-deal antitrust risk assessments for acquirers and sellers, all phases of engagement with investigating agencies, as well as second request compliance. It's Dr. Craig Malam. Craig, welcome to the pod.
Thanks. Great to be here. Hi, guys.
So in case you haven't noticed, Craig is from Australia, and I was curious.
Mate.
G'day, mate. And I was curious if there was any lingo in economics or business that's called something different between American and Australian English. Like, for example, if a company makes a sudden leap to acquire another, maybe you'd call that a kangaroo hop. Or if instead of calling them mergers, you called them the big made up. Or maybe if two companies aren't thrilled about being together, but it's the only choice they have, you'd call that the Vegemite option.
Right. No, there isn't anything that comes to mind. I mean, I'll keep marinating on that. I don't think there is. You know, we have a lot of colorful language around other things, but I haven't noticed any make its way into merger review or the economics of antitrust in that context.
So let's talk about mergers. Can you actually just walk us through what are the actual steps that two companies have to take to merge together?
Okay, so I'm just going to give you, I'm not a lawyer, but I can give you my understanding, the sort of high level steps in the process. So, you know, any company out there right now might be thinking and assessing and weighing different options for transactions. It's usually, you know, part of their corporate strategy to, you know, be keeping an eye open for potential companies to acquire. Or similarly, the company might be thinking about being acquired. So they are on the lookout, and it's probably a regular thing that they're looking into. And, you know, one day, lo and behold, a banker comes to them with a proposal like, here's a company you could acquire, or here's a company you could sell to, and it looks like a good deal. And so they take steps to look into that. They do due diligence. And really, there's a pretty complicated kind of corporate M&A process that gets underway between that company's lawyers and the lawyers of the other company and their external advisors. And, you know, subject to all the negotiations that go on, they might be able to reach an agreement to do the sale or be bought. Outside counsel at that stage, who their outside lawyers are, all along the way giving them advice about various things. But one thing they're giving them advice about is whether there's a risk that some regulator, and it's in the US, it's either the FTC or the DOJ, would create problems for closing on the transaction. They may have an agreement, but would one of these regulators step in and say, no, we think that this could be contrary to the laws of the land, and we'll seek to block it. We'll go to court and seek an injunction. So that's a big risk that they've started thinking through at that stage in the negotiations. But, you know, fast forward to them coming up with an acceptable agreement. They sign. usually in that agreement, there will be a time period that is allowed for both parties to do various things to make the deal close. And one of those things is a time period to do a filing. It's called a HSR filing at the FTC. And
let me just dive in and pause you there
yeah,
for a second, Craig. So, and we're not going to spend the whole episode talking about Dick's Sporting Goods and Foot Locker,
mm-hmm.
but for example, that news came across my various news feeds a couple of days ago, a week ago, something like that.
Mm-hmm.
Time doesn't exist on this podcast. Where would that be in the state? Like, they're announcing they've done the due diligence, but like,
yeah,
could those agencies still step in there? Like,
yes.
what could still happen with something like that?
Yeah, because I think one of those companies is a public company, they've got reporting obligations, so they have to go public with their decision having signed to go ahead and do the transaction. But that's usually when it's announced publicly. Is if it's a public company, it's got to be announced straight away. Private parties, I think, have more flexibility in when they might decide to disclose. But at some point in the regulatory process, if it's investigated by a regulator, it's going to become public anyway. So I would say for the Dick's Sporting Goods one, they're at the point of signing, and within days they're going to be filing their HSR filing. So HSR is Hart-Scott-Rodino, and this is the piece of law that says that anybody wanting to do a transaction, and there's lots of criteria that you have to meet, but a key criteria is that the transaction value be over $126 million. If you're going to execute a transaction like that and it's worth that amount, you have to do this HSR filing that is initially intaken by the FTC, but they go through a process of figuring out who will actually review it between the FTC and the DOJ.
So, at what stage are you coming in to help them kind of assess whether or not it makes sense to merge or whether it's compliant with the law?
It's not so much about whether it makes sense to. They've got a lot of advisors, so the bankers, their management consultants, lots of other people giving them advice about whether the merger is a good idea. We can, an antitrust economist like me, and I have been brought in at the pre-deal stage where I worked for a company that was looking to sell itself to another, and it was particularly interested to understand how that might all play out if they were to approach this buyer and say, "Hey, would you like to buy us?" And so you can come in at a really early stage like that, where the two sides aren't even talking yet, and you can give advice there and do analyses to help counsel's advice to the parties in respect of the antitrust risks. So in that transaction, it's likely that the kind of advice I was able to help provide with analysis was, okay, an FTC or a DOJ reviewing this is likely to see issue X. They're also likely to see issue Y. And based on the information I can see right now, because we haven't approached the buyer, it looks like you'll have a good chance of getting through issue X, or, issue Y here, you're going to have to find A, B, and C.
What's an example of an issue that might come up?
Well, I mean, if we look at if we come back to the Dick's Sporting Goods examples, so Dick's has stated that it's going to acquire Foot Locker. The key issue there is going to be, just looking at it based on public information, is going to be whether there are people who shop for their shoes between Foot Locker and Dick's. So, if you're out shopping for shoes, or you're even shopping online, are you comparing Dick's Sporting Goods and Foot Locker, and do you benefit from those two currently really competing with each other for your business? So the key issue, if I was reviewing that ahead of time, was, how many shoppers do you compete for?
To me, it seems like Dick's and Foot Locker as just a regular consumer, don't share a lot of overlap. I feel like
Right.
if I'm going to Dick's, I'm
Yeah.
going for specifically hiking material that might be separate from whatever they've got at
Well,
Foot
yeah,
Locker.
they have like shoes as one of many different things that they're selling there.
Yeah.
And there may be things that, like when you go online, that you would buy. I mean, the Foot Locker stores have a much smaller footprint. The Dick's are
No,
like a
no pun intended.
superstore. Yeah,
Uh-huh.
exactly. So that
And Foot Locker is global, and Dick's isn't.
no, that's an interesting difference too. But I just think that, it's a very understandable thing because a lot of people have been to those stores and they know what that experience is like. But there's so many other ways now buying stuff online that, I think, what I heard you say, Craig, is that you're trying to give advice about what the regulators might see, whether you would agree with it or not in terms of the way the market would be
Exactly.
defined. You're just trying to say, this is how they would look at it.
This is
And so
one
the
thing that would
challenges would be to
come to
do
them.
X, Y, Z. Yeah.
Yeah. Yeah, this is one thing, and then there could be a bunch of other things.
Right.
And to the extent it's possible pre-deal, you try to evaluate whether those issues are going to be real issues or not. Because you're pre-deal, it generally means that the two parties are not really sharing a lot of information with each other yet. There's a ton of protocols around how the parties should or shouldn't share any information, and so your analysis as an economist, taking that example, your analysis is going to be aided greatly by having access to both parties' data on where are your shoppers, how many shoppers at, say, Dick's Sporting Goods are just coming in for shoes, or is everybody coming in and buying a canoe at the same time? I don't know. And you might argue that if you're out shopping for shoes and a canoe, well, you're not really going to go shopping at Foot Locker. So, as a crazy example,
One of the just kind of sticking with that theme, one of the headlines I saw recently was that as part of this deal, perhaps the newly constituted, Dick's Sporting Goods was going to corner the market on Nikes. And so what if we all agreed, yeah, you can get shoes lots of places, but you now have to go to Dick's and you don't get to go to Foot Locker if you want to get Nikes in particular. So if I don't really care and I'm going to get Adidas or Puma or whatever, but is that a concern? Not just the general item, but the specific brand of an item being available in multiple places.
Yeah, I think that, and so just make sure I understand.
And recognizing you already said this line, but we are not attorneys, so just in your experience, would you see people being concerned about something like that?
Yeah, but let me make sure I got the scenario right. So the idea would be, and this is what the agencies, when they talk internally, will call a theory of harm, right? This is a potential outcome that we're afraid could happen as a result of this merger. And the theory here would be that Dick's is deciding that it could save costs, or there's some other operational reason for just selling Nikes out of the Dick's stores and not selling them out of the Foot Locker stores. Is that
theoretically? I don't know. But between the two of them, I guess the idea would be that anybody else out there would also not have access to the Nikes.
I would think that.
Oh, I see what you mean. Yeah, so that would.
There'd be a lot of questions that would come up if Nike had an exclusive deal with any company, whether it was a company that had just merged or any other retailer.
Yeah,
that would be looked at as being a little bit odd.
Yeah, it would, and that sort of stuff could arise in. So the key with the way a merger gets reviewed is always that whatever the harm is, or whatever the thought, the concern might be about a lessening of competition, that's always something that has to be caused by the merger. It can't be something that's just going to happen on its own anyway, because then we don't have a basis to say that the merger should be blocked. But if there was some reason to suspect that the transaction was going to enable, say, the combined firm to go to Nike and say, listen, guys, we're so big now, you're not allowed to supply Nike to anybody else. We want it all. We want exclusivity. Now, I don't know how or if that could ever work. But in a scenario like that, the agencies would. I mean, if that was a real potentiality, I think the agencies would definitely raise a concern and say that, you know, they would basically say to the parties, if you want to go ahead with this transaction, you have to prove to us why that's not going to happen.
So Craig, I have another question. Maybe we'll see if this works here. The laws haven't really changed that much over time, but it seems like the way in which these laws are being enforced
Mm-hmm.
seems to change. And is there, empirical evidence of that, or is that just what you hear in the popular press that it's going to matter who's running the DOJ, who's running the FTC? Is there any idea that it does really change from administration to administration?
No, I think there is good evidence that it does change from administration, at least somewhat. Everybody has an opinion about how much it changes, whether it's drastic or marginal. But it is true, at least from my perspective, having started in this on this career in Australia, where the laws are really drafted with a lot more specificity. You can't do this, you can't do that. A merger is bad if A, if B. Here in the US, the law really just is quite vague and very high level, and is left. A merger shouldn't be permitted if if it's likely to lead to a substantial lessening of competition. And it really doesn't say a lot more in terms of the detail. It's left to the courts to figure out what that means. And so over time, the courts certainly have, upgraded their understanding of the law and the way the law should be applied on the basis of economics. So since around the 50s and 60s, so for example, there's a really key, still cited to this day, Supreme Court case called the Brown Shoe decision, and it's cited for a lot of reasons about market definition, but it's also cited occasionally because it was a decision that basically said vertical transactions are bad. We shouldn't allow vertical transactions. And since then, courts really moved away from that, and pretty dramatically by about the 90s and the early 2000s, really sort of moved away from any interpretation of the law that would say a vertical transaction is bad. And actually,
And that would be like
transactions
buying your supplier, right?
Exactly. So that would be Nike buying Dick's or Foot Locker. It really does change over time, most certainly. But administration to administration, I think reasonable people can have different opinions whether it's, really drastically changed or not. There's political appointees obviously want to shine a light on the priorities of the people who've sort of appointed them and their election promises. But there's a question. It's a separate question whether in the day-to-day enforcement decisions that a lot really changes. I think in some administrations, it seems to have the enforcement decisions may have been affected, but in other administrations, it's an open question whether there's a lot of talk about certain priorities and but then that's
Right.
to be seen sometimes.
I was asking that because if you think about the labor and employment space, you have sometimes the EEOC or the Department of Labor or a state agency that would correspond to those would bring the lawsuits, but you also have private lawsuits. And it just seems to be the way that you've described it. It's not like Nathan can try to stop the merger because his Nikes are going to be more expensive.
Oh no, technically he can.
He can?
All right. Yeah, he can. Private cases happen, but they're very rare.
Okay.
It's usually always one of the enforcement agencies, the FTC or DOJ.
Right. So I shouldn't say it can't happen, but if there's a change in how aggressively things are being enforced, it may be harder for the private lawsuits to pick up the slack, whereas that may be more possible in labor and employment. That there's lawsuits that are being brought in different ways, and change in administration might have a different kind of an effect on the labor and employment than it would on this.
Yeah, and previous administrations, there's been a lot of commentary about merger enforcement going to be a lot stronger under the Biden administration. But a lot of people found in reality that merger enforcement was, there was a lot of rhetoric and there was a lot of sort of public statements about being aggressive, but it was, a different experience on the ground for a lot of people as to how aggressive they necessarily were in investigating mergers and then litigating mergers, because on those two fronts, the numbers are pretty similar to the previous administration, and then so far under the current administration, the numbers are tracking pretty similar to the way they were under Biden.
So I'm sure that the DOJ and the FTC were as shocked as we were when they heard about this potential merger. They woke up just like we did and learned about this. Are they able to do anything preemptively to say, we don't think you should have this merger? Or do they have to wait for some kind of filing? When do they start doing stuff?
Well, usually, in my experience, usually outside counsel, particularly for these larger deals, will actually phone in to the agency and say, "Hey, we're about to announce. Expect our filing in a couple of days after that." It's a legal requirement that you have to file, so it's not like DOJ and FTC won't ever find out about the transaction, and if they somehow didn't see it in the press. So there are pretty big penalties for not filing when you're supposed to file. And, given the parties have to wait 30 days, so that's one of the rules under the filing, you're not allowed to consummate the transaction for 30 days after the date you file. There's nothing really the agency needs to do to get started early or anything along those lines. They'll use the 30 days, and if it's something that they know they're going to, I guess they would have to be careful about saying we object to this before they've even received the filing, because that doesn't look great. But they will, they'll start doing the work they need to do right around the time the filing comes in, and outside counsel will usually organize meetings with the team that's reviewing the filing, and a conversation and a dialogue will start from there.
What is that relationship like? Are they meant to be adversarial? Are they meant to be inquisitive? How aggressive are they in that time frame?
It really varies. So I've seen some outside counsel that just go in there very aggressively, aren't necessarily going to provide any more information that's needed in the filing. And it's a strategic decision, like dealing with any potential plaintiff. A defense counsel will take different approaches. But then I've also seen, I would say on average, it is a little more collaborative. I think it usually is. You're dealing with a plaintiff who on many of the aspects of the law you're going to be arguing about in court. Plaintiff actually has an upper hand in a lot of ways. The plaintiff being either FTC or DOJ. And so many defense counsel will approach that with a little more of a collaborative, help us, help you type approach. It's certainly from the economic perspective, it's more collaborative, because if economists get involved on the agency side and you get to interact with them to talk about the analysis that you've done and answer their questions about that, it's usually more collaborative than what you might see between two opposing experts in a litigation, where if you're meeting with the people reviewing the merger at the agency, you're a little more like, what kind of questions do you have? You're a completely reasonable person, and I want to help you get to the bottom of your completely reasonable questions.
I worked on a case where it was a divestiture that they wanted in order for the deal to happen, and they're trying to unload this facility, and they just can't get anywhere close to the price that everybody thinks. And really, it was not a merger; it was a settlement in an antitrust case. And it's like, wow, I can't really get what everybody seems to think this thing would be worth, because this apparently is the key to us monopolizing this market. So you think it would be of value to somebody else? Have you ever seen situations where they say, hey, we'll let you go through, but you have to divest yourself of these facilities. And then the company comes back and goes like, yeah, we're not able to get nearly what we thought we could
Yeah.
get. Obviously, that's a forward-looking view of how valuable is it to be in this market. And it just seems
Yep.
like there would be a lot of information in that. And you go, well, maybe we have something
Mm.
wrong here, because we thought these things were going to be worth X millions of dollars. And,
Mm.
you have to trust that they were really trying to sell it for that. But is
So
that
normally,
anything that you've seen?
yeah, no, not really, because usually what happens is the remedy, which is what the divestiture is put forward to the agency with a buyer already in hand.
Okay.
So they're not going to offer, and if you're at the agency and they say we'll do a divestiture, and you say, well, come back and tell me who you're divesting to, because the agency will also analyze whether that divestiture buyer is going to ameliorate the otherwise bad effect on competition. They've
Right, because
been
it could be from the frying pan into the fire or something. Like
yeah,
you
or
sell it to
just
this other entity. Yeah.
yeah, or just from the frying pan into the garbage, right? I mean, what has happened in the past is some of these divestiture buyers have just let the assets die, and it hasn't replaced the effective competition that was lost by the merger.
Oh yeah.
And so,
Yeah.
what the agency really wants to know is, who is the buyer? Does the buyer have the ability to run this business? Is the buyer intending and have financial interests in actually competing hard and running this business competitively? Because there have been cases in the past where even after divestiture buyers have been approved, that those businesses have just kind of gone by the wayside, and you end up with the same problem that the merger was creating.
Right.
So when we're analyzing data, we're often, for our work, we're kind of thinking about, you know, is there a class here? Is there statistical significance? We're thinking about significance in all kinds of ways. We're often getting data that's specifically from a client about their internal operations.
Hmm.
I'm curious, what does the data look like for, a pre-merger decision? Is
Mhm.
significance a consideration, or is it whatever data is available is what we've got to use?
Yeah, it can be, there can be sometimes enough data to do statistical work where you're thinking about significance, but there are also many situations where the analysis you're doing isn't really statistical, where you're looking particularly at a given transaction and looking at the financial incentives that might be involved, say for a vertical transaction. You might though be looking at for a larger transaction where you're thinking about trying to assess the degree to which these these companies may be competing with each other. So again, Dick's Sporting Goods, Foot Locker example is a good one. One way in which you might be thinking you might analyze this with statistics is to look at geographies or areas where people are shopping, um, in which both competitors have an outlet. And then you might look at other areas where it's just one or the other. And if you have enough data on all these different locations, you can actually compare. You can infer the extent to which the parties might be competing with each other by comparing those different areas. So, in area A we see just Foot Locker. In area B we see Dick's and a Foot Locker, and then maybe we can also see that there are discounts and promotions happening at Foot Locker in both places. But in area B, we don't see that Foot Locker's discounts and promotions do anything to the sales of Dick's. And so by comparing A and B, you might be able to infer in a statistical sense that, the effect of those promotions, there's no effect of those promotions on the sales at Dick's. And so that could help us kind of get at that question we raised earlier of, how many people are actually shopping for shoes between these two places.
Well, I guess I'm curious if there's anything that you found that regulators are particularly pleased by, or if it's because these cases are so unique, you've got to look at the individual markets and the individual goods. Is there anything that it really seems like this is kind of the gold standard in trying to evaluate, we're not going to create anti-competitive outcomes?
Yeah, it's really different for a lot of these different transactions. I would say one thing that you could call close to a gold standard is kind of natural experiments. So a natural experiment is where we think that, maybe there was an exogenous reason for some change in the marketplace. And by exogenous, I mean like it's not part of the market dynamic. It kind of happened from outside. If you're lucky enough that the data includes a natural experiment or an episode that you can view as a natural experiment and make inferences from, those can sometimes be very persuasive, because in a merger context, we're always trying to forecast, and so it's a very forward-looking exercise. And a natural experiment is a way of using something that's already happened to infer something about things going forward. So I would say, any natural experiments that come up are usually, when they're useful and they fit in terms of the inference you're trying to make, they're pretty well regarded.
Do y'all have any other additional questions you wanted to ask?
I think Steve should ask his favorite question, which is, how could you ever have anything struck down, and we shouldn't name names too much, but in the existence of an online marketplace that you can get anything from anywhere, Nike's prescription drugs, canoes with prescription drugs, are just a click away.
And I think my general view is that it's all about the market definition in some ways in a lot of these things, because if I define the market narrowly enough, I wouldn't even put Dick's and Foot Locker in the same industry.
Yep.
And there are times when you can say, wow, if it was Foot Locker and another store like it that generally just sold shoes, and they could consolidate, and you'd go, well, now they're like the of the places that look just like that, they have 80% market share. And then the question would be, yeah, but aren't people buying shoes online or at Dick's or some of the other big box retailers that look like Dick's? So I think that's really what the question in my mind is like, how are you going to define that market? And that is really an art more than a science, I would think, right?
No. Well, it might. Yeah, I agree. Like, let me try to explain
some
one.
art, some science, but yeah.
Yeah, it may sound like an art after I describe it to you, but it really is a science. So the concept of a relevant market, and use your example, which is a great one. The concept of a relevant market is purposive, meaning we only define the relevant market for a purpose, right? And the purpose in a merger review is always to assess whether the transaction itself, Dick's and Foot Locker getting together, is going to enable those parties to lessen competition with each other substantially. And so the question about substantiality and lessen competition is, who's going to stop? Let's suppose they do compete with each other. Let's suppose that post merger, there's a bunch of locations in a different geographies where the local Foot Locker is like, phew, now we can just forget about having to compete with Dick's. And the same goes for the Dick's in terms of making these shoe sales. That would be bad, because there's a bunch of people who shop at those stores, and they're now going to be paying way more for their Nikes than they needed to. But the relevant market is the market which tells us whether or not that potential outcome will be constrained or will be prevented. So the relevant market starts from, you look at those two stores and you say, what's going to stop either of those stores from raising their prices? Is it going to be online? Is it going to be another local retailer? And if it is, we've got analytical techniques to figure out whether that's likely or not. Then if those alternatives will stop them from doing that, we include those alternatives in the market definition. And then when we define a market, it and these analytical processes go through to say, well, this is the relevant market. It is such that nothing else will constrain those items. So the purpose is to figure out whether the merger can lead to that lessening of competition, and so the market is defined accordingly to figure out whether those actions can be constrained.
Yeah, and I think that that makes total sense to me. But the way that you're describing this now, we need more information on the sales, not just for the two parties that are merging in
Right.
this particular geographic area, but sales in general of the thing that we think would be affected by this merger. What are the other alternatives there? And so that's where, if you don't have the data, I think that's what I was saying. If you have the data, then I think you
Yeah.
can do more analytical stuff. Otherwise, it's sort of like, well, you know,
You've got to infer. What
yes,
you'd be inferring is you're saying, look, we get a sense for how big in this geographic area, how many pairs of shoes people are buying each year in total, and then we could say that if either of these two firms does a bunch of promotions, they gain some sales. Do they gain them from the other, or do they, or must they be gaining them from somewhere else?
right. Okay, so that was, I think that's very helpful. That's good. The other thing I was going to ask, two other things. One is what I think is a relatively recent thing, and what's your view on this? Am I right? This is relatively recent, that we've been talking a lot about how is this going to impact the consumers,
Mm-hmm.
and I think there are two things that I've seen coming out of the federal government recently. One is, let's apply the antitrust laws directly to labor markets, and the other one might be, even when it is about a merger, maybe the workers will be impacted
Yeah.
by this, and which is a completely different kind of market that we're talking about. Is
Mm-hmm.
that something that's relatively new, and how important do you think that is, looking at other, I guess they would call them like other stakeholders other than just consumers?
Yeah, it's hard to answer that question whether it's relatively new, because there are, according to the most recent merger guidelines that came out in 2023, they quote some case law where courts have held that the antitrust laws apply equally to suppliers of labor, and those court cases seem pretty old. But those cases usually aren't, or at least the ones I saw were not in relation to merger enforcement. They were about some other part of the
Right.
antitrust laws. But yeah, I think it was in labor and applying antitrust to labor was definitely given more prominence under the previous administration. The current administration has said that their emphasis on labor and policing anti-competitive conduct in labor markets won't decrease. They've formed a task force, I believe, to work across the agencies on the issue. Conspicuously, though, for me, at least the statements I saw on labor from the current administration, they didn't include mergers in that.
Right.
And it's an interesting question as to why merger enforcement hasn't been used as much as it for supply for regular mergers as much as it could potentially. So the labor's obviously a big input for most companies, and it's actually it is, according to what I'm told about the case law, a merger can actually be blocked if it will lessen competition between buyers. So our Dick's Sporting Goods and selling sneakers, that's a merger of sellers, but a merger among buyers, if it leads to a lessening of competition, it appears to be that would be against the law too.
Right.
I've heard people say that they think that the number of mergers where there's an effect just on labor, an potential anti-competitive effect, most of those also include an effect on output. And so, the theory goes, well, we only need to block a merger for one reason, so let's just block it for the most easy reason. So if you think about two hospitals merging, there may be, you could assess an anti-competitive effect on local nurses who live locally and who could only supply their labor to these hospitals. Well, on the flip side, you could potentially block that merger on the basis of there being a lessening of competition in the supply of the services that the hospital supplies. And so why not just choose the thing that's going to be the easiest to litigate?
Yeah, and you might have the best data on it, all that kind of stuff. That makes sense. Then I had one other thing here, which is kind of like the anti-merger. I know, and part of what we talked about here with antitrust enforcement really wasn't mergers, but you watch the business news and they're like, hey, there are these magnificent 7 companies that are worth a lot. Like some of them individually are worth like more than all of the equity in like particular European countries across other companies.
Mm-hmm.
And so there's this thinking, I think, that some people have that maybe we need to break them up, or there's some argument, no, given the kind of investments in IT and things like that we need, they really need to have the kind of resources they do, because these data centers and other capital investments are so expensive. You really need to be a giant company to be able to afford them. But when they decide, hey, we should go after this company and try to break them up to get them to sell off some component parts, is it the same group of policymakers at the DOJ and the FTC that do that? The same people that work on mergers? Or is there like a separate group that says, no, we're going to look at it from the other end, which is like, they got so big, we want to break them up?
No, my understanding is it's not the same group, but there is a lot of overlap in terms of the thinking, right?
Okay.
Because there is so the way, at least that I've seen, these companies are pursued, and then a remedy is sought, which is that they need to be broken up. Is that the company has monopolized these markets, and if you think about it, a monopolization of a market is kind of the after effect of potentially a merger that can lead to a lessening of competition. But the argument is that, well, you've broken the law by undertaking or doing these anti-competitive things in terms of conduct, and that's why you've become a monopolist. Whereas the merger law says, well, it's just the fact that one's buying another that you become a monopolist. So,
But it is kind of the agencies that bring that. Again,
it's the same agencies, it's the FTC and
the
DOJ.
same agencies bring it, and with maybe some of the same, certainly some of the same thinking. It wasn't like doesn't matter so much how you got there, but like now that we're here, we never would have approved a merger between these different divisions of your company.
One last thing I want to mention, that you originally, Brent, you brought up the point that these mergers seem to go on, and we, one day are we going to see a firm that's just a combination of all these big companies. The thing to realize, or at least my perspective, if you stand back and look at this, there are thousands and thousands of mergers that are happening every year. There is only really a small proportion that are flagged for further review. Any of the ones over 126 million, and we need those mergers. We need that to happen. We live in a modern economy where things get put together and sold in a package, right? So if you think particularly about software, there are a lot of really useful applications or software providers who are the culmination of a journey of many kind of companies coming together and being put together. And it makes sense that those mergers sort of need to happen, and that's kind of what makes this a vibrant, dynamic economy. But we do need to be careful and look closely at the ones that are designed to give consumers less instead of more. That can be the way to spot it.
What I heard you say makes me feel even better that when Steve and I merged, we were under that 126 million threshold, just barely.
Just barely.
See, I am hopeful for the one mega company that is the merger of all other companies, just so that I only have to create one account for whatever thing. One password. Craig, thank you so much for talking with us, and we'd love to have you back on sometime.
You bet. I'd love to come back. Thanks. It was really fun. Thanks, guys.
Well, that's been this episode of Significance. This episode's been brought to you by Edgeworth Economics, a leader in economic consulting, and with the help of our producers Kimberly Krewald, Ryan Deal, and Brian McLamara of Brand Ready Media, with music by Armwell Lang. Thanks for listening, StatPack, and always remember to check your assumptions.